Join me as I welcome our senior reporter at TechPoint Africa, Tim Gozorin Nwokoma, to introduce our panelists for today. So please put your hands together for Tim Gozorin.
You can do better than that, or whatever they say in church. All right. Hello. I know that a lot of us still have food in our mouths, so I know you may not be able to talk or anything, but first, I'd like to introduce our speaker before he comes up. Omoruyui is a senior partner at E&C Legal, and it's a startup law firm that focuses on Nigerian startups. So, if you've followed Nigeria's startup scene for a bit, you probably have come across him. So he's frequently found giving his opinions and his thoughts on how startups should operate. Anything from whether you should raise money or not, whether you should even hire and fire your employees at will, which is one of the topics we are going to be discussing today. He's very, very knowledgeable about that, and he's actually on the team for the Nigerian Startup Act, which we won't be discussing today. So join me, as Emmanuel said, as I welcome my co-host or my panelist, Omoruyui Edoigiawerie. Okay, so be sitting down here. Okay, I'm supposed to read all of this, but I think we just skip it. So Emmanuel was saying something about employees suing their employers, and it's something that you probably have not experienced if you're not an employer. A few days ago, I came across this interesting bit of news. So an employee had been sent to go on a work trip abroad, and while he was there, he decided to eat, and he had a cap on what he could eat. So he couldn't spend more than £100, £100, on his meals. But for some reason, when he came back, basically submitted what he had spent on food. He was told that the money he spent was like the company couldn't pay for it. And he was worried, why can't my company pay for this? And then they started going back and forth. So it's basically, what did you eat when you traveled? I ate rice, I ate beans, I ate this. And then it was discovered that his spouse or his wife had actually eaten food on that trip, and he expected the company to cover for it. So long story short, took the company to court. The company ended up winning because the company said their policy doesn't allow them pay for a spouse's meal while on official trips. If you're an employer or if you're an HR professional, these are some of the things you probably come across. You probably find employees disputing certain claims. You probably find yourself, I don't know if some of you were around for the earlier sessions where the speaker talked on navigating employee well-being and C-suite executives. What do they need and how can you balance all of that? So those are some of the conversations we are going to be having today. So my first question to you, Omoruyui, would be, I'm a human resource professional. Why should I care about the law? Why should I be bothered about what the law says about HR?
All right. Before I delve into that, I'd like to give you another analogy. And a certain employee was on a work trip, and this is an adult audience, so I can share this story. So was on a work trip and had intimate relations with a woman who accompanied him on that work trip, had a heart attack, and had a medical emergency. And it turned out that he got certain compensation because it was deemed that he was injured in the workplace. Right? Now, I give you this example to tell you that documentation drives the entire journey. And you cannot overemphasize that fact that contracts, agreements, handbooks, regulations, corporate governance documents drive the relationship and determine from important to mundane and from 0 to 100, right? So as an HR professional, as an employer, you cannot afford to look outside the documentation. So the first thing any HR professional will tell you is that the moment you receive a memo saying, hey, fire person A or fire person B, the first thing that any HR professional who understands what he or she is doing would do is to ask two questions: his employment contract and what is the people policy. If you take any decision outside these two, you will most likely be putting the organization into serious legal jeopardy, right? And so, in HR language and in a parlance that we will all understand, documentation form the Bible or the Quran. I don't know what traditionalists use, so I can't tell you, right? That define the entire gamut of that relationship. So, I say to clients every time they have an employee problem, what does the employment contract say? What does the HR policy say? What does your handbook say? Right? And we often forget that employment contracts are not just the documents that you signed when you came on board, right? Your employment letter and your contracts, right? Your HR policy, the organization's HR policy, the organization's whistleblowing policy, your corporate governance documents, all form a holistic contractual relationship between you and that organization. And so it's interwoven. So when challenges come, the only way you're able to navigate those challenges is by going back to the letters of your agreements. And that's why any standard agreement you see, one of the things that you would see is a clause that says you are bound by this employment contract as well as other ancillary documents in respect to your working relationship with organization XYZ, right? Those ancillary documents may be listed in some instances and they may not be. But either way, you've got to care about, for the employer, you've got to care about documentation. For the employee, you've got to care about the fine print.
All right, thank you. So I think one of the things your answer shows is the importance of, well, I say knowledge, because if an HR professional doesn't know exactly what the employee handbook covers, or probably forgets, they could make serious mistakes that could put the company in serious jeopardy. Employment laws in Nigeria are kind of tricky. So yesterday night, I was asking some of my colleagues who are lawyers about Nigeria's employment laws, specifically labor laws. And they said it's not a compulsory course in law school, and yeah, it's not compulsory. I don't know why that isn't compulsory for lawyers, but
It's a specialized aspect. So there are lawyers who are predominantly labor lawyers.
Okay. So for a HR professional, I'm not a lawyer, but those laws they basically govern my practice. What are the specific laws that, as a HR professional in Nigeria? And now, if you hear me focus on Nigeria, it's because all of us here are Nigerians. You're probably not going to be dealing with Kenyans right now. But what are the specific laws that I should be focused on, knowing enough about them as a Nigerian HR professional?
So luckily, the legal regime for the regulation of labor-related matters in Nigeria is pretty simple and straightforward. Okay. You have the Labor Act, right? Okay. The Labor Act provides the rules and regulations, so to speak, that regulate employee relationships, right? Okay. Employer-employee relationships. And then Nigeria is also a party to certain international conventions, right? So we have ratified certain international laws. But let's not go into that highfalutin aspect. Let's just look at the simple, basic, the Labor Act, right? And what it says and what it provides for. But essentially, and you see, labor-related issues are actually one of the simplest and most streamlined because they also have a specialized court. Yeah. Right? You don't go to regular courts for labor-related disputes. You go to the National Industrial Court, where you have judges who are clearly versed in understanding labor-related issues and applying the provisions of the Labor Act. Okay. Right? So we'll talk about the Labor Act. That essentially is. And then you have ILO conventions on different aspects like non-discrimination, equal pay, and the likes, right? And then in addition to that, you also have certain executive regulations like minimum wage. Already, I think in Nigeria we have the Minimum Wage Act, right? But then you have certain other regulations like, for instance, the federal government has a paternity and maternity policy that now provides for paternity leave for fathers, right? And the like. So, yes, so those rules are there. Now, what the Labor Act does is that it gives a window-shared approach to labor-related issues and provides, a clear basis for which you can now deal with an employee. One of the most significant things the Labor Act provides for is that you must give your employee a contract of employment within 3 months of employment, right? So what that means is that if someone has been working for you for up to 3 months, you can no longer continue that relationship in an informal scale.
Okay.
It may look like, okay, that should be what it is, right? But you'll be shocked that there are people that work for 5 years, 2 years, 3 years, and it's just like, okay, come and start working, and then when you're tired, you come and start going, or in our balance, come and be going, But that is actually illegal, right? The law says within 3 months of employment, you must give an employment contract, right? And then there are certain issues, so let's even leave the law and really look at what an employment contract should have,
Okay. Yeah.
right? Because most people sitting here are working or may have worked or may be employers, either way. One way or the other, you've had an employment contract. That really is what you should be more interested in, even over and above what the Labor Act says, right? Because that is the Bible that will regulate your relationship with that organization and will determine how you will go. And as an employer, that is also what will determine whether your employees will sue you or whether you fall out with them or whether you act right or not. So what should be in an employment contract? If you're looking for a job or you get an employment contract, what should be in it, right? Simple things that you would think that people will know, right? Your name, your address, and all that. You will be shocked that some of these things are overlooked, your terms of reference, your job description, right? Your remuneration, and a proper analogy of what that remuneration should include, right? So you find that many employment contracts today leave a very fluid analogy for remuneration, right? But ideally, it should expressly state if you are going to be earning XYZ, this is what you are going to be earning, this is how you are going to be earning it, right? And this is what is expected of you legally. For instance, you know that with employment, for organizations that have more than three employees, you are expected to file certain, to start tax, pay income, and all the like. So this may necessitate some deductions, right? All those deductions must be clearly stated in your employment letter. For an employer, if you say to me that I'm employing you and you're going to be earning 500,000 naira a month, and then at the end of the month, my take home is 350K, and then you tell me that there are certain deductions which were not part of my employment contract, you are creating a dispute, an ambiguity that can make me say, okay, you know what, since we both cannot agree, let us go to a third party who will now determine who is right and who is wrong, right? But if you get your employment contract right, you will find that for a very long time, the parties will have a seamless professional relationship because all the I's and T's have been crossed and dotted. So an employer must know what the law provides for. Do that, have the details, job description, and then termination procedure, when you get tired of working, or when we get tired of you, or when you no longer meet your specifications in this job, how do we let you go? Right? That must be clearly stated in your employment contract. When there is a dispute, how do we resolve the disputes between us? Right? Where do you go to? Do we have internal mechanisms? Right? By internal mechanisms, how do we resolve? Do we have a complaint mechanism, complaint resolution mechanism? So where these things are in that document, like I said, it's the Bible. So when you want to relate with God, you go to the Bible and read and see, oh, you get faith, and you go back to your employment contract and see what your employment contract says. And if there are any specifics that it refers to your handbook, and then you look at the employee handbook, right? What does the employee handbook say about this issue, right? And then you address those issues. What causes problem oftentimes is that you cannot run an organization and rely on the standard law, which is the Labor Act, as a protection, whether as an employer or as an employer. And I must even say to you as a sector player that the Labor Act protects to a very large extent employees more, right? Because an employer automatically, as nature will have it, you are at the higher end of this of table.
Yeah.
So if you want to ensure a balance in protection, you must ensure that the contract of employment is properly done. And this is a caveat for employers who think that it's okay to insert illegal clauses, and now rely on the fact that you signed it. Certain clauses, if they run contrary to the provisions of the law, right? For instance, you cannot have an employee say that if I get pregnant and I give birth, I waive my rights to a paternity leave, right? It's discriminatory, or let's even leave waiving. You can't have an employee say that for the first 5 years or 3 years of working for you, I cannot get pregnant. If I get pregnant, it's a grounds for termination. That's a discriminatory clause, right? And under legal scrutiny will be trashed, right? So your right as an employer to get some measure of certainty with employees stops where your employees' right to be protected begins. So it's a very fine line. And what leads to disputes oftentimes is that employees are always very eager to sign contracts, right? They're always very excited to get a job. And we oftentimes look at the money, and we spend so much time discussing the figures, going back and forth on the figures, and we forget the fine line.
Yeah. Okay, so you mentioned something about inserting certain clauses, and I think it would lead me to one other question I have, which is something that is gradually growing. So in the last 1 or 2 years, we've heard things like quiet quitting. We've heard things like the right to disconnect from work. And these days, almost everybody either has to use a digital device for their job or has to work remotely or hybrid. And we've seen some countries like the US trying to make some laws around the right to disconnect from work. We don't have that yet in Nigeria, but we have a lot of workplaces where they have either remote or hybrid work arrangements. How can an employer ensure that they are basically on the right side of the law when they are enforcing the right to disconnect from work for their employees?
Right. So I'll go back again to the employment contract and to your employment handbook that clearly specifies all the terms of employment, including your working hours, right? But certain employers also do something very funny. And they say your working hours are from 8 o'clock to 5 o'clock or from 9 o'clock to 6 p.m. And then they now add one funny clause, or any time as management may deem necessary, right? Now, that gives employers a very solid leeway, right, to take a lot of liberty. But it's also dangerous, right? And one way of addressing that is to have a standard operating procedure. Now, your standard operating procedure is incorporated into your work policy. And that, by extension, becomes part of the contractual agreement. What is in that standard operating procedure? You should detail disconnection procedure, all right? So when you say someone is working remotely, you're not working 24 hours. So there must be a time when you expect that this person will be online or this person will be working. And when there is a deviation, what are the procedure for correcting those errors, right? When you have a standard operating procedure, it's like plug and play, and it's very important that organizations must now invest heavily in creating proper documentation and standards. So all you need to do is go look at the system. When are you supposed to log off, right? And in emergency cases where you have to be assessed, what is the procedure for that assessment? So for instance, case in point, for my firm, we have a response time within certain hours for emails, right? So during work hours, you are expected to view your email, to respond to emails within 30 minutes, right? Because it is deemed that you have access. And if you don't do that, you should have a cogent explanation for doing that, right? After work hours, we expect that you will respond to your emails within a particular time frame. And then on weekends, those rules are there, right? So it's very clear. And so it reduces ambiguity or any confusion. But even also, what happens that many employers experiment with remote work and the likes, right? Because oftentimes, all we do really is give your employees the tools and send them off to work remotely with very little structure. So it's not like, if the best time for me to churn in my work is 1 a.m., great. If the organization is moving. Productivity differs, right? Yeah. But if you want to have a system that mitigates employee crisis, then you must have a structure to say, within this time and this time, these are the things that are expected of you, right? So that way, you don't have a situation where the organization, it appears, is running you on a 24-hour scale. You, the employee, will be feeling, at one point in time, will begin to feel overwhelmed, that you don't have time for yourself, right? Because the idea with remote work for many people, especially young people, is the flex that comes with it, right? But if you do not understand that you should start at a particular time, finish at a particular time, and within the time that is expected of you, there are systems today, there are AI systems today, for instance, that expect you, even though you are working remotely, to sit in front of a computer within this hour to this hour to do and then you have your breaks, right? You go and come back. And so when you are absent, it's obvious, okay, right? And then at a particular time allows you to do what? Log off, close for the day, right? So those procedures must be in place. And where they are not in place, you just have an open-ended, how do I put it? System, right, that leads to confusion. So the essence of this fireside is to prevent litigation, right, and save employers from challenges. If you don't have a standard operating procedure, especially in this new normal where we have a lot, and so there are so many issues in the remote workspace, right? Regulation, cybersecurity, privacy concerns, health and safety concerns, right? For instance, if you have an employee who's working remotely and that employee doesn't have a proper chair and table to work with, right? And so over time, is sitting up in bed without having a proper rest, armchair to rest her back, or just, and before you know it, incurs a spinal
curvature or something like that.
Yeah, a spinal injury, or somehow. Yeah. What are the implications of some of those things, right? Because what people forget is that the new normal also comes with new regulations. Yeah. And some of the regulations also give employers the obligation to have HSE standards in place for remote work, which means even though you're working remotely, do you have the adequate facility and technology to work adequately from home or remotely?
I think one takeaway for me from this session is the value and importance of documentation, because all of this can always be solved if we have a standard document that just says
Yes.
this is how you do things, this
Yeah.
is when you do them,
Yeah.
and this is why you should do them. I
Yes.
think it saves not just the employer but also the employee, because if I'm an employer and you're the reason I'm in court, I don't know I'm going to take it. So I think it's very important for those of us who are HR professionals to take documentation very seriously. So even if for some reason your current workplace doesn't have that procedure, I think it's, with this knowledge you've gotten, I think it's just a responsibility that you make sure you have one by the time you get back. So we are gradually coming to the end of this, but I think we can take one or two questions. So if you have any question, you can start preparing them. So I'll take one more question. So,
And sorry, just to point out something, please avoid copy and paste approach. Right? I run a startup. It's an e-commerce or it's FMCG or tech. Especially the fintech space. Right? Because there's so much regurgitation, dangerous regurgitation. Every business is bespoke, right? My law firm is different from another person's law firm. Their procedures are different from mine. But you see, when I copy their procedures, hook, line, and sinker, because I just want to comply or I just want to appear, especially in the, let me shake a table, we're in the startup space where we look for investors and we seek funding all the time, right? And I just want to get funding. And so I want to have all my books and records in place. When problem comes, you find that this documentation, this HR policy, this standard operating procedure, this privacy policy, whatever your procedures are not fit for purpose because they are not bespoke to you. You copied them from another person who probably copied from someone who did it bespoke. So what happens? No, there's nothing new under the sun. You engage lawyers. Lawyers will take what exists. But the difference is that they will now ask you for your personal circumstances, your organization circumstances, the kind of businesses you do, and the structure that you have. And then based on that, they will modify what is existing and give you something that will be fit for your purpose. Why do I say this? Checkpoint, for instance, you have certain things that drive your objectives and policy, right? And part of it may also, may have a lot to do with remote work. But if I give you the HR policy for Guardian, right, that builds a policy where journalists have a workstation where they come into work. And so the policies that regulate their employment is based on that workstation culture. Meanwhile, you are building a global media, tech media brand that should be able to work with people from Nigeria to Australia. You will find that those policies will not be fit for purpose.
All right, thank you. I'm getting the nudge to stop, but one more question. Non-competes are a thing in Nigeria, and the idea is to protect the employer's IP, but how can an employer strike the balance between protecting his or her IP and also ensuring that employees are not exploited?
So, two things. We fixate heavily on non-compete agreements and very little on non-disclosure. Confidentiality, is that the right word? Confidentiality, right? Confidentiality agreements are very, very important. NDAs do more for you than non-competes and, non-disclosure, non-solicitation and all that, right? Because even the law, for instance, reduces, if you have a non-compete, for instance, that says if you work in Tech Point, you cannot work in any tech media-related company for 5 years. All I need to do is go to court and tell the court that this clause is illegal. And the court will declare it as such, right? But if you have a non-disclosure that says whatever business secrets that Tech Point has and that are accessible to you, right? You cannot disclose those secrets 5 years after working. It's a non-disclosure agreement. If you do that, you are liable to legal damage. That's more potent, right? And so businesses must start driving their protection not from a place of market competition, but from a place of product sustainability and protection, which means have proper non-disclosure agreements in place with your employees. Then also ensure that you tie in. So what causes problem, especially in the tech and creative space with employers, is ownership of created work. You work in TechPoint. Now let's assume that this fireside chat discussing this employee rights is a product of your idea, right? And you brought it up to Muyiwa and the team, and then they said, okay, you know what, Chim Gozirim, run with it. And then you invest so much and you run with it without proper documentation. It becomes your thing and your marketing tool. Now you can another company, let's say X Media comes for you. You want to move with this employee fireside chat to that organization. And then it becomes a tug of war. Now when you look at the end of the day, neither TechPoint nor you owns it, right? Because of failed documentation. But imagine if in your employment contract, you clearly stated that everything you produce, every intellectual property production is going to be owned by TechPoint. It will not be clear to you that whatever I'm developing for TechPoint. Now, at the time you decided to create this fireside, you could have gone to HR or sat Muyiwa down and say, hey, I want to have a chunk of this ownership, or I want to retain ownership of this product. Can I do that? Right? So that reduces the conflict. Do you understand me? Because where you have employment agreements, you have non-compete, you have non-solicitation clauses, they're very good, right? But oftentimes, if you meet me in court, I will tear it into pieces. Many employees see me as their worst nightmare. Why? Because those agreements that you make your employees sign, many employers, employees sign, will not stand the test of time in legal scrutiny. So what is the use of an agreement that when it's time to enforce it is useless? But when you have proper NDAs in place, you protect your intellectual property. And employees must now, as you create products, clearly tie in ownership of these products. Because it is human beings that create these products. HR First was coined by somebody in the TechPoint team, right? Now that person in TechPoint team can't take that phrase to another organization, right? Because it's owned by TechPoint. And you have the proper documentation to tie that in.
All right. Thank you so much, Omoruyui. I don't know if anyone has a question, just one question, and then you move. All right. Okay.
Hello. So my question is, if a project is my idea, I worked on the project, I built the project or I built the product. It's my idea. It's my sense that I put in the product. You as a company will now say it is your product and you have intellectual right to it. Please help me make sense of that.
So why did TechPoint, now I know you don't work for TechPoint, but I'm just using this analogy. Why did TechPoint employ you? They employed you for your sense to come up with ideas that will help them move forward, right? And so a valid employment contract, especially if you are employing a creative, must clearly state who owns whatever creative products that come from your work, your time of work with that organization, right? So now, if you have peculiar circumstances, right, and you want to create something personal to you, you have two options. Notify the organization, reach an agreement with them, or build them independent of the organization, provided that your employment contract allows you to do that, right? But if you build a product for an organization and the organization runs with it, it is domiciled with them if your employment contract says so. But if your employment contract does not say so and your employer does not realize the need to tie in ownership of intellectual property, then it can swing it away. It depends on who has enough muscle to argue their case. But it will most likely be more to your benefit because you are the creator.
So since I am the creator of that, it means I can replicate it somewhere.
Sorry?
since I am the creator,
Yes.
I can replicate it somewhere else. So why should I be sued for replicating an idea that belongs to me?
Right, right. So here's the thing. Here's the thing. Whatever you are creating for the organization, right, you have a non-disclosure, right, to create, let's say, a particular product, right? If it's a flagship product for the employer, it is expected that the employer should know that they should tie in a proper system in place that protects, that allows them enjoy the benefits of it. So what is the beauty of HR First if you can have, stimulated conversations like this around a particular topic, and then it's duplicated in so many places that waters down the effect of what TechPoint is trying to achieve, right? So if you go and then name it something else. So the thing about intellectual property duplication or theft or watering down is that if it appears so similar to confuse or create a market competition, then there's a problem, right? So you may not have that liberty if the right documentations are in place to go and say, okay, no, let's not call our own HR First. Let's call our own resource launch or something else, right? And you really can do that. So, oftentimes, one of the biggest dilemmas we have as intellectual property professionals is that we say to clients, there's really no way you can perfectly cover the field when in terms of protecting, creative and intellectual property rights. But you can only mitigate it by having the right documentations in place. So you can go ahead and do what you want to do, but the truth is, if there are very clear similarities, you'll be breaching a term of your contract and you expose yourself to legal liability.
All right. Any other question before we move on? Gone. All right. Thank you so much to every one of us who sat down, and thank you, Omori, for always being willing to share your thoughts and your knowledge. Thank you so much.
Thank you.
All right.
Please, a round of applause for. Thank you so much. We learned a lot.